Well, those are, of course, the recommendations of the Law Commission. We have to now see what the government is going to do and then what the courts are going to do. So, for more on that, we're now being joined by Mr. Satyapal Jain, Additional Solicitor General of India, someone who's been a member of the Law Commission as well, and, of course, someone who's one of our most respected legal minds. Mr. Jain, thank you so much, sir, for joining us. I just wanted to get your sense of what the Law Commission has said on sedition, because clearly, this has been a very controversial law, something that's been debated for years, if not decades, something that many people has often been misused to, sort of strike against free speech or against dissent. What's your sense of what the Law Commission has said?
See, you are right. For the last so many years, especially after the matter went to Supreme Court in May 2022 last year, this matter has come again for discussion in the public domain. The Supreme Court itself expressed its opinion that this issue should be deliberated upon. Supreme Court stayed all the proceedings under 124A in all the courts in India last year. And the matter has now been examined and the report has been submitted by the Law Commission of India. As you know, Law Commission practically is not a statutory body. It's a body which has evolved over the years, and all the courts, Supreme Court, High Courts, they refer to the reports by the Law Commission. First thing I wish to say is this, that the recommendation of the Law Commission of India are the recommendations of the Law Commission. They are yet to pass the scrutiny of the government, parliament, subcommittees, standing committees, etc. In a sense, I feel that the Law Commission has taken one step further in the field of having wider discussion on the sedition law. This is what the Supreme Court also wanted.
So sir, just to understand what you're saying that the Law Commission, whatever it says, is its recommendations. These are clearly not binding recommendations and are not necessarily what the government will eventually want to do, or for that matter, what the Supreme Court will eventually want to do. It is an input into the process. Would that be a correct way of looking at it?
Yes, see, not only the government. First, the Law Commission recommendation goes to the Government of India. The Government of India examines it. Suppose the Government of India agrees or disagrees or they want to take it further, then it will go to the Parliament. Parliament will ultimately send it to the Standing Committee. Standing Committee consists of representatives from all the political parties. Again, it will come to the Parliament, and if any amendment has to be made, 124 will be amendment in the Indian Penal Code. This can be done only by both the houses of Parliament. So in a way, the point which I put up earlier, it's a good step, one step forward in the field of having larger consultation, larger participation by different groups, different ideas, in the ultimately going to a law which has the least controversies as much possible as possible.
I think you're right, sir. Of course, the more you debate, the more you discuss, the more you're likely to come up with a positive solution. Now, one of the things that do come out from what the Law Commission has said, for example, Law Commission says you should not do away with tradition just because it is a colonial law. You shouldn't do away with the law just because it's a colonial law. Now, people may debate that because they will say that a colonial system has certain repressive measures which do not really have a place in a democracy. In a free country or a democracy, you don't need some of the repressive measures that are there in a colonial system.
You see, so far as the first argument is concerned, simply by saying that it is a rule or law enacted during colonial rule, if we have to strike down all laws, I am afraid as a lawyer, how many laws you will have to repeal? The entire Indian Penal Code. The entire Indian Penal Code was enacted during the British rule. There are many laws which were enacted there. Simply because it has been enacted during the colonial rule is no ground to strike it down. Number two, see, the section has stood the scrutiny of the Constitutional Bench of the Supreme Court in Kedarnath Singh's case in 1962. You know, Allahabad High Court had declared it null and void. So, a law which has already stood the scrutiny of the Supreme Court, which has already stood the testimony of different courts, and which has once again been reiterated by the Law Commission, will again be open to discussion and debate in Parliament, and both sides' opinions will be available for taking a final decision.
All right, so one part of what you're saying is don't repeal a law just because it was passed in British times, but One of the other things that comes up is that shouldn't these laws be defined a little bit more specifically and more precisely so that they cannot be misused, they cannot be used for harassment, for example, there can't be fake cases filed in there, just to harass people because those provisions are there. That is something which, if it's a very loosely worded clause or very loosely worded provisions, that is something that is possible. So does it need to be defined in a far more rigorous manner? Actual incitement to violence, actual violence is committed, mens rea in some form.
Yes, I am personally of the view, number one, that this law must retain the law book. You cannot go away, you cannot get away with it. I am of the view, personal view, that the law must remain. Number two, so far as the definitions are concerned, even Kedarnath Singh's case, even the Law Commission has recommended that these things should be clearly specified. 2-3 things. Number one, what will be the actually sedition? Intention, they have suggested the intention to incite violence, etc., etc. Number two, see, the biggest guarantee in the law is, first, the clarity by the executive, the parliament, legislature to define the law. Second is the implementation by the investigating agencies. How do an inspector or a police constable or head constable visualizes it and he analyzes it? Third will be the courts, which will ultimately decide whether you are guilty or not. I think these three mechanisms, if they are taken in the logical end, I think ultimately something concrete will come. The argument which is given by many people that since there is a possibility or apprehension of misuse of this clause, so it should be repealed. Once again, I will say as a lawyer, if any apprehension of any law likely to be misused or abused is an argument to strike down the law, I'm afraid there will not be even a single law in the country which has not been misused.
Yeah. So would you agree that one of the simplest ways of ensuring that laws like this cannot, or any other law cannot be misused, is that there should be some accountability? If somebody actually misuses a law, for example, the sedition laws are used against somebody who was not committing sedition, ended up going to prison, was locked up for 5 years, 10 years. Later, it turns out that that law was actually misused by somebody. The way to handle that is then there should be accountability. There has to be something in jurisprudence which says if you misuse a law, there will be consequences, you will be punished. And if that happens, then the chances of misuse also go down. The probability of misuse certainly goes down.
Already in the law, there is a provision for prosecuting any person for malicious prosecution. If somebody involves you falsely, after your acquittal or after that, you can move for the malicious prosecution. You can go for the damages. You can go for other remedies also. They are already available, but no harm. If in such a law you make a provision for taking action against those who falsely implicate you. But I'll say, I believe in the independence of the judiciary, and before concluding, I'll give you 3-4 examples, short. Number one, it is the independence of the Indian judiciary that a single judge of the Allahabad High Court set aside the election of the sitting Prime Minister of India, which example you will not find in the entire world. Number two, a 5-judges constitution bench of the Supreme Court struck down the National Judicial Appointment Commission Act, which was passed unanimously by the Parliament. All parties, all MPs, 900 MPs had voted for that. It was struck down by the Supreme Court, 4-1, everybody accepted it. In the case of Mr. Navjot Singh Sidhu, after 34 years of incident, last year he was sentenced to go 1 year's imprisonment. I have all regard for him. I'm not at all criticizing him, but I'm telling you, the independence of the Indian judiciary is the biggest guarantee to avoid any misuse or abuse of the law.
All right, Mr. Satyapal Jain, Additional Solicitor General of India, thank you so much, sir, for joining us for that. Let's see now what the government makes of the recommendations of the Law Commission and what finally happens with this somewhat controversial law. Thank you so much for joining us, sir. Thank you.